Welcome to the 7th video of a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. As we noted in the other videos, I am intentionally giving away all of the substantive content of the book. If you watch all 9 videos and internalize the concepts explained in those videos, you will have expert knowledge of interrogation law without spending anything but your time. I think that you will find, however, that the book, and particularly the many case examples found in the book, are a valuable supplement to your viewing of the videos. It is bargain priced and available for purchase on Amazon. But if you choose not to buy the book, the free YouTube videos stand on their own and provide real value to viewers. So, on to today's lesson. This is video 7, which covers speedy arraignments. In a series of cases starting in 1943, the United States Supreme Court held that voluntary confessions could be suppressed in federal cases if they were obtained in violation of the federal speedy arraignment provisions in Criminal Procedure Rule 5. The key concept in these cases was that these confessions were inadmissible if they were obtained after an unnecessary or unreasonable delay in presenting the arrestee before a magistrate. An arraignment that is delayed for the purpose of allowing time for interrogation is the quote-unquote epitome of unnecessary delay. But a delay for legitimate reasons, such as shortage of personnel necessary to process the arrestee, is not unnecessary or unreasonable delay. This is often referred to as the Mcnabb-Mallory rule. Title 18 U.S.C. Section 3501 C, enacted as part of the Omnibus Crime Act of 1968, modified this rule by creating a 6-hour safe harbor for delays. The Supreme Court has interpreted that statute to mean that the Mcnabb-Mallory rule has no application to confessions given within 6 hours of arrest. That's the safe harbor, but continues to control delay outside the 6 hours. This is sometimes referred to as the Corley rule. Delays that have been recognized as reasonable include those caused by the need to verify an alibi, medical care or time for the arrestee to sober up, shortage of governmental personnel, time to secure the search premises, and time to translate oral confessions into written confessions, and the unavailability of the magistrate. Federal speedy arraignment statutes only regulate arrests of individuals for federal crimes. The 6-hour clock does not start for state prisoners arrested on state charges until the prisoner is also arrested on the federal charge. If the interrogation is likely to continue outside the 6-hour safe harbor and your suspect is cooperative, cover your bets by obtaining a waiver. The FBI uses a waiver form that's set out in the FBI's Domestic Investigations and Operations Guide at section 19.4.1. The Mcnabb-Mallory and Corley rules are federal rules regulating federal prosecutions grounded in a federal court supervisory power and a federal statute. They are not dictated by the United States Constitution. Consequently, they have no binding effect on state custody or state prosecutions. Many states have their own speedy arraignment statutes and case law, and they generally take one of three different approaches. Some states allow their own versions of the follow their own versions of the Mcnabb-Mallory rule and suppress confessions taken after unreasonable delay. Other states only require suppression where a violation of a speedy arraignment statute directly induces or is used to extract a confession. Finally, other states view violations as reasonable factors, as negative factors in the totality of the circumstances test for voluntariness. In other words, these states will not suppress a voluntary confession based on a violation of a speedy arraignment statute. The Fourth Amendment requires probable cause before an arrest warrant may be issued. The Supreme Court has held in Gerstein v. Pugh, 1975, and County of Riverside v. McLaughlin, 1991, that the Fourth Amendment also requires a prompt judicial determination of probable cause after a warrantless arrest. A judicial determination of probable cause within 48 hours satisfies the Fourth Amendment requirement of a prompt determination unless the determination was delayed for the purpose of gathering additional evidence to justify the arrest, was motivated by ill will against the arrestee, or was delayed for delay's sake. Supreme Court has expressly declined to rule on the appropriate remedy for a violation of this rule. Most likely, a voluntary confession obtained in violation of this rule would be evaluated like any other fruit of a Fourth Amendment violation, using the Brown factors that we'll discuss in the next video. The United States is a party to the Vienna Convention on Consular Relations, the VCCR. Article 36 of the VCCR indicates that law enforcement authorities must ask detained foreign nationals without delay if he or she wants to have their consulate notified. If the foreign national says yes, the authorities must notify the consulate. And finally, if the consulate then requests to speak with or visit the foreign national, the authorities must allow a visit. The State Department publishes specific guidance for law enforcement officers regarding these procedures on its website. This is a formal obligation that state and local law enforcement must follow. That being said, a failure to provide the notification will not result in the suppression of statements made after that failure. Nevertheless, there are a number of reasons to provide the proper notification, whether or not the exclusionary rule applies. First of all, it's the law. Secondly, courts have not determined whether the foreign national might have personal rights under the VCCR, whether one could, for example, bring a civil rights lawsuit against the arresting officer. Courts could view a failure to provide consular notification as a negative factor in a totality of circumstances in determining voluntariness. And finally, you might have to explain during cross-examination why you did not follow the law. So, you made it to the end. Thanks for that. This was the 7th video in a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. If you have comments about the presentation or questions about some of the points I've tried to make in the video, I can be reached by email at contact@trialdex.com. The next video covers exceptions to the exclusionary rule, impeachment, and fruit of the poisonous tree. I hope to see you there.